125th meeting of the House of Commons Standing Committee on Industry and Technology. We are taking place in a hybrid format pursuant to the standing orders. Pursuant to the order of April 24, 2023, the committee is resuming consideration of Bill C-27, Digital Charter Implementation Act 2022, and we are continuing with the clause-by-clause consideration of the bill. And I would like to recall to the participants that there are important preventative measures in the room to prevent potential harmful audiophilic incidents. We recall that all participants should keep their earpieces far from the microphone, and that in accordance with the additional measures of April 29, the following measures have been taken to help prevent audio feedback incidents. All earpieces are disconnected when you take them off. Please put them down on the appointed spot, and please confirm and conform to the measures for preventing soundbacks. I thank you for your cooperation to prevent incidents and to ensure the well-being of our interpreters. And thank you very much for your cooperation. And so once again, this Monday morning, I would like to welcome Mark Shan, Senior Assistant Deputy Minister, Strategy and Innovation Policy Sector, Samir Shaba, Director General, Strategy and Innovation Policy Sector, Runa Angus, Senior Director, Strategy and Innovation Policy Sector. And welcome to the committee. And as you know, we left off at CPC 9. And Mr. Perkins, you had the floor at that time, and you have the floor again.
So I yield the floor to you. And members, I don't have whoever was left on the list to talk about CPC 9, so please manifest yourself if you're interested in speaking on CPC 9. But Mr. Perkins, the floor is yours.
Thank you, Mr. Chair, and thank you, everyone. Welcome back. I'd like to begin. I know this is going to shock MP Turnbull, but with moving the motion I put on notice with regard to SDTC. Hopefully we can dispose of this quickly. As members will recall, as part of our work plan, we had scheduled one more meeting on SDTC with 4 witnesses that we had passed through a motion here. Vina Bueller, the former liaison between SDTC and ISED, ADM Andrew Noseworthy, Navdeep Bains, the minister of the time, the change of the chair, and Gianluca Cairo, the former chief of staff. And the reason we asked for those witnesses to appear was after the former CEO's testimony, Leah Lawrence. She spoke quite a bit to the interaction she had with those individuals about the conflicts that the chair had and the objections and concerns that the management was expressing relative to the proposed appointment. And in fact, the department, some of these officials came back and said, well, that's okay, we'll manage through the conflict. Others of these officials were actually part of that process, according to the former president in doing this. As well, ADM Noseworthy had sat in on all the board meetings and has, I think, a bit of contradiction between what he said versus some of the other testimony. For that, we said we would like to have these witnesses back for a meeting in May, and the clerk had dutifully invited them. They all declined. All of them declined to appear before the committee.
Mr. Perkins?
No, hang on. I'll get to that. Yeah. All of them initially declined. And when I tabled the motion to summons them and put them on notice, miraculously, Mr. Noseworthy said, "Okay, I guess I'll come as an official. I won't get summons." I think that's a dark comment on parliamentary respect for these former ministers, chiefs of staff, declining to appear. So the motion that I have on notice says that, and I'll just briefly read it, that the committee summons the following witnesses to speak on matters related to allegations of conflict of interest at the Sustainable Development and Technology Canada. A, Vina Bueller, former liaison between ISED and SDTC. B, Andrew Noseworthy, ADM Clean Technologies at ISED. C, Navdeep Bains, former Minister of Innovation, Science and Industry, and D, Gunluka Cairo, former Chief of Staff to the Minister of Innovation, Science and Industry, and the witnesses be asked to appear at a time determined by the chair, but no later than June 7th. And the reason is we gave them more than a month to appear, and Mr. Noseworthy has agreed to appear, so we don't need to summons him, but we do need to summons the others who are refusing to appear. So I would hope that the committee will deal with this expeditiously and agree with me that it is a slap in the face to the parliamentary process that the other three, A, C, and D, on that motion are refusing to appear and must be summoned to appear on this important matter. This does not add any meetings to our schedule. It was already scheduled as part of our approved steering committee report, which was approved also by this committee. So with that, Mr. Chair, I'll leave it there, and hopefully there might be a few questions or comments, but that we can move on. So it would be A, C, and D who would be summoned, not Mr. Noseworthy.
Thank you, Mr. Perkins, and I'll yield the floor to Mr. Turnbull. But just before, as a small clarification, it's not clear that all the witnesses listed have refused to appear. Some have not yet replied, but I just wanted to clarify that. But it's true that it's been quite the process trying to get this meeting organized on SDTC. We've been trying with the clerk for some time now.
That's what I was going to ask, Chair, is just for clarification on what invitations have been sent out and when they were sent out, and a little bit of just a bit of information to provide context to Mr. Perkins. I think it matters because I don't think that we should use summons lightly. I think it's a step only to be taken when the committee really feels like it's the only option left at their disposal. And often in some committees we've had multiple invitations before we summons individuals. Thanks.
So I might yield the floor to the clerk, or correct me if I'm wrong, Madam Clerk, but so we're still waiting for a response from Vina Buller. Andrew Noseworthy has agreed to appear on June 5th. Mr. Bains is not available on June 5th due to a prior commitment. But that's for that specific date. In the case of Gianluca Chiaro, we're still waiting for a response for June 5th, but he has been invited, was not available in May. We're still waiting for a response for June 5th. So that's where we stand. And I have to say, the witnesses were invited for different dates in May as well. We've pushed it back to June 5th to try to accommodate. So far only one witness is confirmed. But in the case, for instance, of Vina Buller, there's no indication that she's refused. We're just waiting for an answer. We haven't received anything. Mr. Gahir.
Great. Thank you, Chair. I guess I have a question regarding, is this even the proper committee to be hearing this testimony? We have the AG's report that's going to come out on this issue. It's going to go to public accounts. I think that would be the proper committee for this to be discussed at. We have an important bill in front of us, important legislation, and this is just delaying our discussions on that topic. It is.
I will just to before we get into a debate on whether we have voted unanimously on a steering committee report that calls for one more meeting on SDTC with the witnesses listed. So it's an agreement that this committee agreed to unanimously to have this meeting before the end of the session. Ideally, it was supposed to be in May. Now we're in June. So I just want to me, this meeting is locked in a way. We've agreed to it. Monsieur Garon.
Just a question. Maybe we could. Maybe someone could tell me. I don't. If I recall, I think that we had agreed on two supplementary meetings, one on Rio Tinto and one on the waste, and I think that's what we had agreed to. And are we still keeping with our agenda as planned without hindering the C27 consideration, as that's what I've understood? So in other words, the discussion is whether we're going to summon these people or not. Exactly. And maybe my suggestion as chair would be, since it's being discussed by the committee today, My suggestion is that everything is there in the. Maybe we could do it on Wednesday, Mr. Perkins. We could see if there's any response from the witnesses, and then we could come back to it maybe on Wednesday.
This is the second time we've asked former Minister Baines under this study to come. The first time he refused. Now he's been ragging the pup. This is 5 weeks since we passed this motion. They were given all of May, and the motion said to appear in May, that this committee approved, to appear in May. I think we've been more than generous to these witnesses to try and accommodate them without further delaying. We do have another piece of legislation, MP Singh's bill, that is most of our hearings in June. So we had an agreed schedule that was agreed to in the steering committee, unanimously, including the Liberals, which included this meeting before the end of May. And in order to accommodate, as the chair has said, and MP Turnbull and MP Kahira said, we've given them all this time. The first invitations went out at the beginning of May when we passed the motion. It was public. And they have been saying, oh, I can't do this date. I can't do that date. I can't do this date. It's clear that they are refusing through delay tactics in appearing and hoping that the summer comes and everybody will forget about this. This has nothing to do, you'll recall, MP Gahir, with whatever it is that the Auditor General is doing. We have our own inquiry, which we've done on this, which we still cannot do a report on until we've had these witnesses. That's part of the process that we all agreed to. And to go back on that is amazing to me that the Liberals would want to go back on what they agreed to in the steering committee report. They would want to go back and not have the meeting that we agreed to when we passed this motion almost 5 weeks ago. So summons is strong, but 5 weeks of trying to get these witnesses to appear has been more than accommodating. It's time to use that hammer. And that hammer is the only thing that got ADM Noseworthy to agree to come.
Yeah, I mean, so Mr. Perkins, I agree with you on one thing, which is that we agreed to have a meeting on SDTC. We didn't necessarily agree to these particular witnesses. We said we'd invite them. We didn't agree to summons them. So, and we all know that the Auditor General's report is coming out relatively soon, and that this issue of SDTC and the discussion of what to do is not, just going to evaporate into thin air. It's going to be a conversation that we need to continue to have. And I think, so, why do we need to summons these witnesses now when one of them hasn't even got back on the June 5th date? It seems a little bit heavy-handed to me. I believe it is. I mean, I recognize that your desire here is to have those witnesses. But I mean, when I spoke to other committee members, and they expressed that they weren't all that interested in studying SDTC until the Auditor General's report came out. So in fact, I think that it's a little bit heavy-handed to go with the summons at this point. I'm not breaking any deal. The deal that we had was to have a meeting on SDTC and to invite.
Before the end of May. That was the schedule.
Well, yeah, okay, but
what's
so
the date today?
The chair didn't end up
May 27th.
being able to schedule the meeting until June 5th. So is that my fault?
No, that's not the first attempt.
Colleagues, this is not how the committee works.
But
if you
Mr.
want the floor,
Perkins is suggesting that somehow this is as a result of me breaking some deal, which is not the case. That is absolutely not the case.
We had a deal at the end of May. They were
okay.
approached.
Mr. Perkins, if you want the floor, you have to seek it, and I'll recognize you so you can speak.
You can speak next, Mr. Perkins, if you disagree with me, and you're more than welcome to disagree with me. We've had lots of disagreements in the past, and I'm sure we'll continue to disagree on things, and occasionally we agree on something, which is always a nice, serendipitous moment when conservatives and liberals agree. So let's see if we can get there on this. But I don't agree with the summons as being necessary at this point. I think it's premature. And perhaps maybe we need to consider adjourning debate on this today and coming back to it. But I'll leave it to other committee members to weigh in. We haven't heard from Mr. Massey to see where he stands on this, but would be very interested in any comments he has to provide.
Thank you, Mr. Massey.
Thank you, Mr. Chair. And I'll be honest with you, at this point, I just want to get it over with. It's a distraction. So I'll agree with the motion to get this done and move on, because there's lots of good work that we need to happen. I get to see this going in circles continuously. And I don't want to revisit this in another motion in another few weeks. And we did agree to have a meeting, and it's taken this long. So I understand where the parliamentary secretary is coming from, and I understand where the clerk and the chair have done their due diligence, but I don't see how we really can get this completed and done, which we said we'd do. And I don't want to kind of go into that or have a special session in the summer related to this. And that's where I see this going. And I don't want to have more parliamentary resources and summer meetings just because we can't get an answer on things.
Thank you, Mr. Massey. Mr. Turnbull.
So if I may, I wonder, so is Mr. Massey, if I could just ask for clarification, so you're agreeing to summons these witnesses, and that's an appropriate step you think we need to take at this point? I'm just asking for clarification because I think that's what I'm hearing you say, whereas I kind of think that that's a little bit premature, but that's just my sentiments on it.
Yeah, I don't know what else to say other than we're in this situation because of decisions other people have made. I don't like the idea of summoning people. That's not something that I prefer to do. But at the same time, I have a bigger concern with regards to the time that we have at this committee, the resources for the House, and respect for our process that supersede that. And I don't know what else to do other than, one of two options. Either just get this done. They kind of made their own bed to some degree, either by not responding or responding in a way that doesn't really accommodate the committee. And second of all, I also know that this is going to come back again. And I don't really feel like spending parliamentary resources on special committee meetings or having summer sessions to accommodate, which I haven't heard a good reason from the people coming back saying that they even propose another date they wouldn't be here. So I don't know what else to do. I don't like it, but there's lots I don't like.
Mr. Massey, trust me, there's nothing I want less than having to come back to Ottawa for a meeting on SDTC this summer to chair in person. So I appreciate your concerns. That said, colleagues, I would have a bit of a proposition, and I'm looking at Mr. Perkins, and I'm coming back to this proposition. I think summons should be, and it's up for the committee to decide, but I think summons should be really the last resort. And I understand your frustration, Mr. Perkins. I share your frustration in many ways. With the clerk, we've been trying to invite these witnesses for some time now. But now that we've debated it, and your motion states that we can go to June 7, I would propose that maybe we ask the clerk to look for any additional resources that we can find next week, where we offer a variety of time slots to the witnesses for the week, for next week, and whenever whatever works with the witnesses, they'll be on notice that there's a summons that's been debated here at INDU, and that it's most likely going to be voted on Wednesday. If they don't cooperate and find some time in their schedule to appear before committee next week. That would be my middle-of-the-road proposition, so we get back to this first item of business on Wednesday when we meet. And that gives the opportunity, one last opportunity for the witnesses to cooperate. Mr. Perkins.
I appreciate the middle of the road, but I think we've been more than generous, and I would prefer to do a vote.
Want to put it to a vote, Mr. Perkins? Okay, because just as
so we can get on to the C-27.
For sure, but this was not public until today.
Chair, the motion still includes a witness that's already agreed to come. So I think that's problematic. I can't summons and vote on a motion. Like I say, we adjourn debate on this today and revisit it later in the week when we have more information. So I'll move to adjourn debate on this.
So this is a dilatory motion. I'll ask the clerk for a roll call.
Support.
Okay. Mr. Gahir.
In favor?
Ms. Sidhu.
In favor?
Mr. Badaway. Mr. Van Bynen.
Yes.
Mr. Genereux.
No.
Mr. Perkins.
No.
Mr. Viss.
No.
Bless you. Mr. Williams.
No.
Mr. Garon,
No.
Mr. Massey,
No.
So the motion to adjourn debate is defeated, which gets us back to the motion at hand. Are there any other comments on the motion, Mr. Turnbull?
So this motion needs to be amended before I can vote on it. I really don't feel comfortable voting to summons Andrew Noseworthy if he's already agreed to come. So who's going to amend this motion to remove him? Because I'm not going to allow a vote to, you know. Yeah, well, I guess I can amend it myself. I'll move to amend this by
I
striking
think I
B.
didn't read his name. I said he doesn't need to appear when I read it.
Yeah, when you read it, that's true, Mr. Perkins, but the text that's before us still includes it. But I understand Mr. Turnbull is moving a sub-amendment to remove...
It actually would be
an amendment, sorry about that, to remove Andrew Noseworthy. So is
Correct.
it
Just strike
it's an
B.
amendment. Yeah. So is it the will of the committee to adopt the amendment? Yes, I see there's consensus. So so now do I have any other speakers on the motion as amended by Mr. Turnbull? Seeing that there are none, I'll put it to a vote. Madam Clerk.
I vote no.
Mr. Gahir. No. Madame Sidhu. I didn't hear you.
No.
Mr. Badaway.
No.
Mr. Van Bynen.
No.
Mr. Genereux.
Wait.
Mr. Perkins.
Yes.
Mr. Viss.
Yes.
Mr. Williams.
Oui.
Mr. Garon.
Oui.
Mr. Massey.
Oui.
Alors, la motion est adoptée. Merci, chers collègues. Et ce qui nous ramène à...
Thank you very much. The motion is adopted. That brings us back to our agenda. We were at CPC 9 of C27, and Mr. Perkins had the floor. As I mentioned, I don't have any speakers, any other speakers on my list. Mr. Perkins.
I believe, did I move CPC 9 or who moved CPC 9?
Mr. Williams
did, okay. Since Mr. Williams moved it, in terms of the testimony from officials at the last meeting we were discussing this, I'd like to propose a sub-amendment, if I could, to it. I think it reflects at least one of the concerns, maybe not all, but one of the concerns of officials, if I could. Have you got it handy that you can circulate? You need to circulate it. So what I'd like to propose is a sub-amendment with regard to CPC 9, and in one of the English version of the amendment, I would propose that it read, by deleting line 6 to 15 on page 51. That's what it would read, and just as an explanation, that's instead of what it currently says, which is lines 1 to 15 on page 51. So I believe that officials raised a valid concern regarding CPC 9 in the last meeting related to the deletion of the private right to action. This was an error on our part during the drafting process when trying to delete the cross-references to the tribunal and removing the preconditions necessary to conduct a private right to action. Conservatives support the private right to action, and this proposed sub-amendment will ensure that private rights to action can continue under the CPPA while also strengthening the process by removing the mandatory preconditions. So I was circulating it perhaps. I know I just sort of dropped this on if officials can take a look. So essentially what we're doing is saying deleting lines 6 to 15. So lines 1 to 5,
Point of order.
there are
No,
ones that
just,
deal with the
Mr.
issue
Perkins,
of-
just
I'm
one
really
second.
sorry to interrupt
So,
you.
no problem.
I really need a copy of this just before
She's
we
sending it to
continue.
the clerk. He's sending
Yeah,
it to the
I'd
clerk.
really like to be able to read because I couldn't follow the deletions of the lines that you
Get it,
just
yeah.
mentioned. And
We're just sending to
in
the clerk.
relation to a fairly long piece and an important piece of this bill, I really would like to have a copy in both official languages. Maybe we could just take a moment to suspend and get that so that everybody has a copy so we can follow along. Thank you.
That makes sense to me. So we'll wait for the sub-amendment to be distributed, and the meeting is suspended. Okay, chers collègues,
Dear colleagues,
colleagues, please. Order. I believe the sub-amendment by Mr. Perkins has been circulated in both official languages, so members and officials have had the chance to take a look at it. So thank you for that, Mr. Perkins. I'll yield the floor back to you.
I'm correctly pointed out, thank you to the clerks, that I missed one word, which is in line 5, the word if, which starts off those following sentences, should also be deleted.
Duly noted.
Thanks.
So, Mr. Perkins, you still have the floor if you...
Well, I think if I want, okay, sorry. So the idea here was to put back into the amendment, which I understand that the government doesn't support the overall amendment. I get that. But the idea here was we had never intended to get rid of the concept of the private right to action. So perhaps on that particular aspect, I could get some comments from officials.
Merci, Monsieur le Président, pour la question.
thank you very much, Chair, for the question.
As it relates to the current sub-amendment, what essentially is being reintroduced is a portion of the private right of action. So what has been reintroduced is the first 5 lines, so 107.1 essentially. But in both the French and the English, you'll note that there are prerequisites for the purposes of the private right of action. So in 107.1, it ends with, in English, if, and in French, selon le cas, and there's a couple of conditions related to when a private right of action would apply. And so in the case of what has essentially been designed as the kind of scheme for private rights of action is not an unfettered private right of action. That is, that individuals aren't simply allowed whenever they feel like they've been aggrieved on an personal information issue to be able to go forward. The court of first instance is the privacy commissioner. And so hence why the current prerequisite reads, A, the commissioner has made a finding under paragraph 93(1)A that the organization has contravened the act. And then AI, so the first, that the finding is not appealed, or as I understand it, there is some consideration as to whether or not there should be appeals or simply judicial reviews, but that the finding is not appealed and the time limit for making an appeal or a judicial review under subsection 1012 has been expired. The tribunal is not actually introduced until 2 of that, which is that the tribunal has dismissed an appeal or the finding under subsection 1031, or then B, that the tribunal has made a finding. So essentially, what has been reintroduced is only a very partial scheme of the private right of action, which actually introduces an unfettered private right of action. That is, that there is no first instance finding of the privacy commissioner, but in fact, actually, that anybody who believes that an organization has contravened the act or has a cause of action against the organization for damages or loss can simply pursue that. And so we actually have had instances and concerns related to private rights of action in previous other pieces of legislation where there's unfettered access, essentially. And the fear, of course, is that this creates what some people have suggested is a class action law, factory, because suddenly anybody is actually empowered for the purposes of being able to create legal actions where they believe their privacy has been contravened, as opposed to allowing the first instance finding, which is the case of the Office of the Privacy Commissioner, to have actually weighed in, and in those cases where there is a finding, to say now you can actually pursue civil damages under the Act. And so, I understand the thought process here, which is that stripping out the PRA was never the intent, but actually what's been reintroduced is not the PRA as was understood in the first scheme of the Act, but actually an unfettered PRA.
Thank you. That's clear. We have another amendment that's way down, CPC 70, that basically this was intentional, what you're saying. It wasn't an unintentional miss on our part. This was an intentional thing because if an individual does not want to wait, the effect of this is, as I understand it, that if an individual does not want to wait, say, for 2 years for somebody to get through and the cost of getting through the privacy commissioner's issue, they can go directly to the court themselves to get a finding without going to the privacy commissioner. It would be the effect of this, correct?
So right now there are no bars at all. So there's no gating at all for individuals who wish to pursue direct court action against
With this amendment.
with this amendment.
Whereas in the current CPPA, there is.
In the first instance, in the current understanding of the PRA as it was introduced in the statute, or as in this draft, there is a bar, which is that the commissioner has heard your complaint and ruled that it is actually a violation, and therefore you're then allowed to proceed on a civil basis for penalties. That was done for a number of reasons. One is the privacy commissioner is the first instance arbiter of privacy considerations, and the second is the potential for a massive amount of actions that would clog the courts, some of which may or may not be founded.
Perhaps, we don't know that, and we don't know that it would be a massive amount that would circumvent the privacy commissioner, but it does give the individual the option of pursuing going straight to the court without having to pursue that after waiting, for a lengthy privacy commissioner.
Essentially, what it does is create a dual track. So you have one track where individuals essentially don't have to wait for a trusted entity to actually have made findings as it relates to privacy violations, and instead, those who can and are privileged enough to be able to kind of mount a case would be able to do so. And we have seen instances in other legislations where there are private right of actions without necessary conditions, and that does potentially incentivize behavior to try and encourage people to see what they can get through, and then the possibility of being able to share in any benefits that come from that. And I don't believe our concerns about the possibility for volume are necessarily unfounded. I think Mr. Chaba wants to add to my point.
Thanks very much. I just wanted to point out that I think it would also result in the creation of, as Mr. Sean pointed out, 2 tracks, but also the possibility of scenarios in which privacy commissioner's views or interpretation of the act would be different than what a court might find in the similar circumstance. And so you're now creating a situation where there are multiple arbiters of the act and its interpretation, its application, which creates a huge amount of uncertainty, both for Canadians, for businesses, et cetera. It's a very different formulation than what's been proposed to date.
Thank you.
Merci beaucoup. J'ai sur ma liste M. Turnbull.
Thank you very much.
Mais là, on est sur le sous-amendement de M. Perkins.
Thank you, Chair.
Merci, Monsieur le Président. Je comprends bien ce qui a été dit pour répondre à Monsieur Perkins. Peut-on prendre un pas de recul? J'essaie de comprendre comment ce sous-amendement se lie à la proposition initiale de CPC 9. On enlève l'idée du tribunal de tout le projet de loi. Nous en avons déjà parlé. Ici, ce qu'on essaie de faire, il me semble, c'est de modifier l'article sur le droit privé d'action. Monsieur Turnbull, je ne vous entends pas. Est-ce qu'on pourrait régler le problème, s'il vous plaît? Nous allons jeter un coup d'œil sur ce qui se passe. Monsieur Massé, est-ce que le problème persiste? Il y avait une espèce d'écho sans volume. Il semble y avoir un problème avec le canal anglais.
Yeah, so I'm trying again. I see that it's been solved. It's fine. Thank you, Mr. Massey. Mr. Turnbull, you may resume. Thank you.
Thank you very much, and I'm glad to know that Mr. Massey is attentive to my interventions. I appreciate that. Okay, great. So where I was trying to understand again the sub-amendment in relation to CPC 9. CPC 9 again removes the tribunal from the bill. Which I understand is pretty central because the bill was contemplated based on the tribunal being part of the overall legislative framework. But this new sub-amendment looks like it deletes all of A and B and removes the if from page 51 of the English copy, which is 107.1, the private right of action. So what is really the effect of that? That's what I'm trying to understand. Obviously, we didn't have any notice of this, so it just a little bit, I think needed to clarify for all of us just to make sure we're on the same page. Thanks.
Merci, Monsieur le Président, pour les questions.
Thank you very much, Chair, for the question.
As noted, the original CPC 9 essentially removes references to the entirety of the tribunal in every instance of its appearance in the Act, thereby essentially removing the current kind of separation between investigative and complaint findings of the Privacy Commissioner and the offence findings in terms of the penalties. But in so doing, it also stripped out the entirety of this section related to private rights of action. Private rights of action obviously are a separate consideration as it relates to the kind of overall schema of the Act. The notion is that the Privacy Commissioner is obviously an extraordinarily important part of our overall protection of the fundamental right of privacy. It allows for individuals to make complaints to the Privacy Commissioner, for the Privacy Commissioner to investigate those and to make determinations onto the applicability of the Act, and then to make recommendations in the current proposal of the Act to a tribunal for the purposes of administrative monetary penalties, or to issue orders, potentially as a remedy for that privacy issue, or, as is potentially imagined in some of the amendments that may follow, to reach a consent agreement with the parties as to the appropriate rectification of the privacy finding. What was imagined in the original schema was one additional kind of tool in the toolkit is Privacy Commissioner investigates, determines the applicability of the Act, comes to the conclusion that there is actually a finding of fault or that there's a violation of the Act, decides to issue an order, decides to come to a consent agreement, or decides to come to the conclusion that there isn't a finding of a violation, potentially with the recommendation for an administrative monetary penalty. But what was allowed for in that particular instance was for an individual to say, I'm taking my finding and I'm actually going to pursue damages on my own right. So the Privacy Commissioner has found that there's been a violation. Maybe he didn't recommend DAMPs. Maybe he actually went through some other mechanism. Maybe he issued an order. Maybe he made recommendations because it wasn't found that the bar for AMPs was necessarily met in this particular instance. But the individual then would still be able to take that finding and be able to come to the courts to say, my privacy has been violated. The Privacy Commissioner has not necessarily recommended the full outcome that I feel I'm in possession of. And so therefore, I'm going to pursue this action for further damages. What the reintroduction of the private right of action in this particular instance does is give back that power slightly, but actually instead of kind of becoming a pass go once you've crossed the board, pass go and then collect $200. It's essentially saying you don't have to pass go anymore. You can just, if you feel like your privacy has been violated, if you feel like there's a contravention of the Act, go to the courts and see whether or not you get $200. And the challenge that it introduces is, as we noted, this was part of a multi kind of factor toolkit to say, here are the various ways in which fundamental rights of privacy are going to be protected. The Privacy Commissioner is going to be able to make determinations and investigate and then recommend amongst a series of things in order a finding, a recommendation of an AMP. And then if you're unhappy or still feel that there's additional kind of considerations, you can then pursue a private right of action. This actually says private right of action, which, as Mr. Chopper noted, introduces two wrinkles. One is we don't know how many individuals are going to be motivated nor capable to be able to bring their own private right of action in the case without a finding, which means that we may actually, because there's no barrier to entry other than the fact that you need to have a court take it on, essentially, there could actually be considerable volume of individuals who bypass the Privacy Commissioner and go straight to the courts. Second is we've now asked the court to play the same function as the Office of the Privacy Commissioner. They are resourced and created in the system to be the finders of fact and the interpreter of the act for violations of privacy. So we have an investigations-based system where essentially people make complaints to the Privacy Commissioner. They interpret the act on the basis of the investigation that they consider and then make a finding and a recommendation. What this essentially says is you can go that path, or you can go directly to the court, and now the court is actually placed in the position of doing the same role that the Privacy Commissioner would, but it actually therefore bifurcates the interpretability of the act. We now have two bodies that are in the position to say, well, when I read this act and I see this particular violation, I see it this way, and I see this as a violation. But the first instance interpretation of the act is now spread between two bodies, which does introduce the possibility of conflict and does introduce the possibility of uncertainty. And so from our perspective, I think there are three kind of considerations as it relates to the sub-amendment. One is the notion that we now have a private right of action without any barriers. Second, we have two potential sources of interpretation, and then this fits into a broader scheme where potentially it fits into a broader amendment that actually removes the tribunal in its entirety, which therefore is once again consolidating a number of the powers into one body as it relates to the investigation and complaints function, and then the actual determination of penalties.
That was a very thorough explanation that certainly helped me understand the impact of this, what's being proposed here. It doesn't sound like it has a whole lot of positive consequences based on your initial assessment, and would cause, based on what you're saying, is that individuals who want to pursue the private right of action could do so. Wouldn't this have quite a lot of impacts on the court system, and would it not clog up the courts? And how would individuals determine whether they have a good case if they haven't gone through a track and process where in a way there was an investigation that already had happened? I think that it seems to me that the cases might be weaker or be inclined to be weaker, and individuals to stake claim to compensation for harms that, I don't know, may not be as justifiable under law. Just a thought, but maybe you could build on that if I'm right, or correct me if I'm wrong.
So I think I'd say a few things. One is one of the most important elements of this statute that's been retained from its predecessor, PIPEDA, is that it remains a principles-based and risk-based statute, which means that it's intended to be technologically neutral and applicable in a vast array of situations. It is not granular insofar as to prescribe in every single instance what a company shall and shall not do. It's principles-based, which means that its interpretation is actually extraordinarily important and grows with time. And so one of the challenges of taking a principles-based statute and applying a private right of action without a finding of first fact, without a first instance finding of violation from the body charged by Parliament with its interpretation, is that you're actually allowing for a wide variety of readings as to what is at stake here, and so it's not. I can imagine instances in which a private right of action is introduced in instances where the legal test or the interpretation is extraordinarily rigid and understood in every instance to say, well, it's just as easy for me to figure out whether or not there's been a violation here as it is somebody else. But that's not actually what's at question here. This is a principles-based and risk-based statute for which extraordinary deference is given to the Privacy Commissioner in their first instance findings of violations. This is something that actually ties back to one of our concerns about the removal of the tribunal. Is the tribunal is actually not vested with relitigation of findings of fact. We didn't actually try and introduce a second body who gets to be able to determine what is or is not a violation of our privacy laws. They get to make a determination of the appropriateness of an administrative monetary penalty. So actually, one of the concerns that we have or one of the kind of considerations that we had in creating the tribunal is actually introduced in this particular sub-amendment in a new way by essentially giving another body, that is the courts, who now will make first instance determinations of findings of violation of privacy.
So thank you for that. One of the other things that occurs to me when I heard you explain that was that individuals may not be able to easily determine whether a violation of their privacy rights has happened. And I think when you think about operating in a digital age as we are today, you may suspect it, but I would think that it puts a lot of onus on an individual, and how would they have the capacity necessarily, as you sort of said, the first instance finding would, in the model that was contemplated for this bill, would happen through the OPC. And so by removing or allowing an alternative track, I guess, for someone to pursue a private right of action, it seems to me to put a lot of onus on them to have to investigate or know how to determine whether a violation has actually occurred. Is that part of the challenge that you see that would kind of weaken the overall approach if this were to pass?
Certainly, previous statutes and this one empower the OPC to be an investigatory body. It's given resources for the purposes of coming to the determination of whether or not a violation of privacy has been taken by a commercial actor. Essentially, by allowing a private right of action without a finding of violation from the Privacy Commissioner, you are essentially asking courts to do that, which courts are good at many, many things, but what we've tried to do in the schema of this entire setup is to preserve for the courts that which is truly necessary. So give the Privacy Commissioner all of the due deference on interpretation of the Act, findings of violation, all of the investigatory powers, the ability to make orders, preserve for the tribunal the administrative monetary penalty setting, and then preserve for the courts only those parts where there's literally a failure of the law, where people have misunderstood the law in its entirety, not a finding of fact, but actually on an appeal basis. What this essentially does is say, you can go that track, you can go to the OPC, but you can also go to the court. And if you go to the court without having gone to the OPC, they're now going to be charged with the test of, well, is this a finding of violation or not? Which means you're essentially giving them an investigatory role, which is not what's envisioned in this scheme, nor is it necessarily what they're set up or resourced to do, and moreover actually potentially creates the possibility for dueling investigatory findings, because notwithstanding the fact that it's not, one would like consistent outcomes every single time, the reality is that there are folks who are, particularly when we've got an Office of Subject Matter Expertise in the Privacy Commissioner, we've got a body that's actually set up to be able to know how the Act is supposed to apply.
So would that remove the I mean, look, one of the arguments the Conservatives made when they introduced the original CPC 9 amendment was that it would somehow erode the powers given to the OPC. This sounds like it would, like I was arguing last time, and I think you were providing some helpful testimony that that wasn't the case with how the bill was contemplated, but but this sub-amendment, I think, certainly has that effect. Would you not agree that this effectively almost allows for people to opt out of utilizing the Privacy Commissioner and its investigative role becomes somewhat, I don't know, I wouldn't say obsolete, but it certainly seems like they can just choose a different track and bypass the Privacy Commissioner.
What the sub-amendment contemplates is the possibility for two distinct bodies. One, a body that is a subject matter expert created for the sole purpose of making findings as it relates to violations of privacy, and enshrined in law as the interpretive body for the statute, because by its investigatory power and its findings power, it has the ability to determine what is or was not offside of the law. Instead, we now have a new body with wide responsibilities, so not necessarily the subject matter expertise that potentially comes with having this as your sole job, having the same capacity now to make findings of violation and therefore interpretation of the statute in competition with, or at least in parallel with, the Privacy Commissioner, and essentially does, at minimum, bifurcate the interpretation of the Act. It gives it to two bodies. Because essentially by allowing a court to make a first instance finding of a violation and making rulings on what is and is not a violation in first instance, they are now essentially equal to the Privacy Commissioner in coming to that determination.
So you have one track where you have an individual and contemplated a tribunal that has expertise interpreting the statute, and then on another track you have the courts who may not necessarily have the expertise interpreting it, and that those two interpretations may come into conflict from time to time, and we might even expect them or anticipate them to do so, given, well, I don't know if there's historical context for this, but I imagine if you were designing a process, you would probably not create two tracks that are going to cause interpretive conflicts in how the statute is interpreted. I mean, that wouldn't be ideal. Am I right? You probably wouldn't do it that way. So I can understand why it wasn't contemplated that way, but this sub-amendment has that effect. That's what you're pointing to. What are the ramifications of those interpretive conflicts as we move through? And then who actually who would decide on what effectively becomes the interpretation if those interpretations come into direct conflict with one another?
So one can imagine a time period in which the two findings would actually live simultaneously in conflict, because you could have essentially I'll try not to use legal jargon, but like a first instance ruling, so like stare decisis, a path-dependent kind of approach to how one approaches particular types of activities and violations of the privacy law, which is then the prevailing standard upon which further violations are heard. You could, in parallel, have a ruling of a low court that comes to the conclusion that there's actually been a violation of privacy that's not in keeping with either the current practice of the Privacy Commissioner or potentially how the Privacy Commissioner may ultimately come to that conclusion. And those two, until such time as potentially in appeal, would or a future finding by the Privacy Commissioner, so you'll live in a world of uncertainty for that time period. So what might happen is the Privacy Commissioner gets a similar violation down the road and comes to the same conclusion he or she has previously and says, just for the record, I'm making it known to lower courts that this is how I continue to view the interpretation of the Act and its applicability. Or you could have someone appeal the lower court determination, and the privacy commissioner may or may not seek to try and influence the outcome of the appeal to say, by the way, so that's the potential risk that's at play here, is that for a time period you could actually have a period of uncertainty until such time as the privacy commissioner can recommit their views on a particular subject, and then you may very well have conflicting judgments. You could have a lower court that's made a determination that is at odds with the current interpretation as understood by the privacy commissioner.
And so who determines what becomes the sort of precedent or body of law? Because then you have direct conflicts in the interpretation, and then so you have essentially the OPC in terms of its history of decisions. So it's sort of got a body of precedents in a way, and then the courts would as well, and they would be on separate tracks. And even though so could you then choose if you were to analyze the body of evidence in the courts or the OPC and just choose which one you feel is more favorable to your particular case? Would that be something that someone would naturally want to do, is pick the environment where they would be most successful or most likely or have the highest chances of success? That seems like a very strange unintended consequence of this.
There certainly is incentivized behavior potentially for people to find a venue that they believe will be more sensitive to their cause, and so you may very well have people avoiding the OPC and finding instead to go to the courts until such time as the law can be clarified. This would lead to more challenges until either the Federal Court of Appeal or the Supreme Court can make a determination in these particular instances. And then I think it's worth remembering that this goes back to living in the schema that's set out in CPPA. So in the government's version of the statute that's before members right now, the privacy commissioner investigates, receives complaints, makes investigations, makes determinations, uses the full toolkit available to the privacy commissioner, orders, findings of violation, recommendations of administrative monetary penalties. And in the government version, if he goes the AMPS route, or he or she goes the AMPS route, the tribunal rules on AMPS, and what is then only reviewable is not findings of fact. So again, the privacy commissioner's view would be determined as per the privacy commissioner's original findings. There are other amendments that are coming later, potentially about making it only judicially reviewable if there's a determination. So you'd have one track potentially on the private right of action side that has this possibility for regular review and renewal on the part of the courts, because you'd get different courts kind of reviewing it. And then on the privacy commissioner side, findings of fact on their violation that will not be reviewed because it's determined that he or she is actually the sole determinant of findings of fact and violation as it relates to the interpretation of the act. So you'd have two very jarring systems, because one has a ton of variability and one has privileged an actor to say, you're the first instance finding and we've got belief in your capacity and will only continue to kind of appeal insofar as you potentially have made an error in law, or potentially that we want to review the determination of the tribunal. That's the last thing I'll say is there are other powers associated with that investigatory function that are quite important, which is the compulsion of information, for instance. So they're a resourced body for the purposes of investigating people's complaints about privacy. The court is provided with what evidence is provided before them. And so the appellant the plaintiff and the defendant in this particular case will be the sole determinations of the information that the court can make a determination on, as opposed to in the case of the OPC, where they fill the record with what they need to be able to come to a determination on the fundamental violation or not.
That seems like a really big difference. In cases with the OPC involved, that they're taking on that investigative function, so they're they're gathering all the evidence to make a determination, whereas in the separate track where the courts are, where you're going direct to the courts, who would be responsible? So each one of the plaintiff and would be responsible for hiring their own investigators? Like, who's investigating? We're not talking about criminal law here, are we? Like, who's actually doing the investigation? It's not the police force. So who is it?
So the defense and the prosecution would both mount their respective cases and place information on the record of the courts to make their determination. And the court is bound to make a determination on the basis of both case law and the information that's been placed before them by both the defendant and the plaintiff. So it would be up to the two parties to ensure that the court is furnished with sufficient information. And so unlike the privacy commissioner, who has a compulsion power that allows them to fulfill the record with what they need, the court would be limited to that which is actually before it, which means that because there is no investigation, it would be a slower process, because essentially they're having to furnish the court with all of the recommended information, and one of the parties does not necessarily have compulsion powers to be able to force that evidence to be able to be put before the court.
And I mean, it would be slower significantly, but also more costly for the individuals who are seeking compensation for a violation of their privacy rights. Would it not be a lot more expensive for them, not having a first fact finding from the OPC to base their case upon?
So the schema we imagined as it relates to private right of actions is the first finding of violation essentially allows people to be able to kind of proceed to court with a finding, and allows the court essentially to make the determination as to whether or not additional remedy is required or justified. But it's supposed to be a short circuiting in part because there's already been a violation, a founded violation from the entrusted resourced entity for which the legislation holds responsible for making first instance determinations of privacy violations. That's not the case in a private right of action scenario without that requirement.
One thing that also occurs to me is that from an access to justice perspective, if the OPC were not involved as essentially performing its investigative role in these cases where you're pursuing a private right of action through the courts by bypassing the OPC, essentially you're having to spend more money, I would think. You're having to wait longer. And we're talking about individual people whose privacy rights have been violated, or at least feel that has happened. So they're seeking compensation for the harms done to them. And we're saying, no, you can go through the court system, which may be more favorable if you feel like it, but it's going to be more time intensive, more costly, and you may not obviously get the sort of decision that you're looking for, obviously. So doesn't that also create another asymmetry that so people might be motivated to go to the OPC in one respect if they're lower income or they don't have the resources, and if they do have the resources, they might find themselves paying costly fees and going through the court system. Would that not be the case?
I think that's an accurate concern about this approach, and the second kind of consideration is because there is the prospects of monetary penalties at the out of this, is that you might actually see particular behaviors in the marketplace start to form. Whereas, have you been a victim of privacy violations? Call 1-800 privacy violations, and then we split the rewards on a contingency basis, and so suddenly there's a bunch of people who are kind of brought into either class action or other types of actions within the court system on the premise that there might be kind of gold at the end of the rainbow Whereas, in the OPC process, we've actually empowered people to have violations, on a finding of fact where there is a learned body entrusted with protecting their privacy and then making determinations.
Okay, so I don't understand why the Conservatives have proposed this. I get that maybe the intentions were good in some world, I don't know, but this just seems like it has a lot of adverse unintended consequences. And I'm not a fan of doing things sort of on the fly. I believe that the government and the team has put a lot of time and energy and effort into contemplating a robust legal framework that I think fits together and tries to streamline the process to be as effective and efficient as possible, and to probably not have significant delays in terms of justice being served. I note that Mr. Williams used the phrase that justice delayed is justice denied over and over and over again. It seems like this particular sub-amendment would delay justice considerably, and thus it sort of, I think, violates the intention of some of what the Conservatives have said multiple times. So I'm not sure where this is coming from, but it seems like a half-baked idea that is really not going to serve the interests of anybody at all, and actually create mass confusion. So I certainly am not supportive of this sub-amendment based on the testimony, Chair. I know that are there other people on the list, so I'll yield the floor for the moment and put myself back on the list, because we can't have this sub-amendment go forward. I won't let it.
Thank you, Mr. Turnbull. Mr. Massey.
Thank you. To the officials, is it true that whether we have a tribunal or no tribunal, or this process that's presented, or maybe an alternate, that any case could eventually end up or will end up in the courts if the parties want that to be the case?
So I think I need to unpack your question slightly. So as it relates to the matter before this, as it relates to this private right of action, what this contemplates is whether individuals will have the capacity to bring their own efforts before the courts as it relates to privacy violations. In the scheme that was initially provided for in the bill, it imagines that individuals do have that capacity, but only after the commissioner has made a determination of a violation of privacy, unless that violation is under appeal, or that the tribunal has dismissed an appeal, or the tribunal has actually already come to a determination. So if you've closed your case, as it were, before the track that includes the OPC and the tribunal, then the private right of action is no longer there. But if it's an open-ended one, then you can pursue it. As it relates to the sub-amendment right now, we are imagining that individuals will be before the courts at the same time as potentially someone might be appealing an OPC ruling.
Sure.
As it relates to the...
Understand.
Oh, yeah, sorry.
I understand that, yeah. No, I understand that, but the question was, we can, like, even under the tribunal process, we could still end up at the courts. And I understand what you're saying is that there would be steps before that that would take place, but there still is the courts is the ultimate backstop for any model that we have in front of us. That's what I'm looking to. And I understand there could be different stages, but there's nothing stopping anyone from suing at the end of the day if they don't like the model that we have in the legislation with the tribunal, or alternatively with another model that might be presented.
So I'll say three things maybe, and I'm going to turn to Mr. Chhabra and Ms. Angus for two of them. One is, to your last point, it isn't actually possible to necessarily find yourself before the courts in the current model of the bill, because in order to find yourself before the courts, you need a finding of violation by the privacy commissioner. So you actually, that's a ticket to entry. So it does reduce the number of kind of court instances where this is potentially the case. In the case of the current model, though, as you note, what happens when people don't like the determination that happens. Maybe I'll turn to Mr. Jobber and Ms. Angus to kind of identify again what role we've given the courts as it relates to what they can and can't opine on as it relates to this, because I think it's important, because at the core of this is who has interpretation and investigatory responsibilities under the Act. And in the scheme that's currently provided for under C-27, the role of the courts in their actual consideration of OPC findings is actually relatively limited in certain cases. And so I'll turn to Ms. Angus to kind of walk through that.
Sure, thank you very much. So I'll just talk a little bit about here on this amendment, we're talking about a PRA, private right of action, which is about damages. So it's somebody who has lost something because of a privacy violation, and they go to court to make themselves whole again. So this is not about correcting the privacy, violation. It's about making themselves whole again, and getting damages for the loss that they suffered. And in that case, as Mr. Shan said, the track is, the OPC makes a finding of a violation, and then that plaintiff takes that finding of violation to the court and say, look, there's been a violation. The OPC says so after an investigation, after an inquiry, and I've lost X, Y, Z because of this privacy violation, whether that's reputation or anything else, and I would like to be made whole again through damages, and that's that track. And then there's another track, which is the OPC making a finding that could possibly be appealed to the tribunal, and that is the actual finding, and then the tribunal acts as an oversight mechanism for that finding. It's not a dual track as it would be for a PRA that Mr. Shan discussed. It's really an oversight mechanism, not a dual track. And that cannot be appealed to a court, as we discussed last time. That is actually a final decision on a particular factual finding. So and in that finding, the tribunal gives deference to the commissioner on findings of fact and findings of mixed law and fact. And that cannot be appealed to a court. That can only be judicially reviewed, which is entirely different. It's not a substantive consideration of the merits. It's just a question of whether the tribunal acted reasonably or not. So is the court a backstop? It's always a backstop, but how you get there, whether it's on a PRA or whether it's on a finding of a violation, it's very different, and it's a different standard of review, and the court plays a different role in each of those situations.
Okay, so thank you. That's been helpful. Now, with regards to the amendment, can we not create a model where we amend the amendment so that the privacy commissioner is then, completed their investigation first, and then you can go to the courts? So I'm not entirely enamored by this tribunal. I do appreciate the arguments of, complicating things for the privacy commissioner with a two-stream process that's undergoing, but can we not create a piece of legislation that would have the sanctity of the privacy commissioner continued to be the first step before any court process?
So, Mr. Chair, as it reads currently in the proposal, in the bill itself, that would be achieved through the continuation of the inclusion of what was in the draft text. So right now, the Conservative sub-amendment stops at line 5, where there previously was an if. That if is gone, and essentially what that if does is I believe do what then you propose, which is the if of A is the commissioner has made a finding under paragraph 93(1)A that the organization has contravened this act, and 1, the finding is not appealed and the time limit for making an appeal under subsection 101(2) has expired. It goes on to talk about a tribunal determination, but at minimum, A and 1 get at the notion that this has to have been first reviewed by the privacy commissioner to allow for a private right of action to proceed.
would, and thank you for that, it would, including the part two, be more specific in the sense of direction for that process. That's kind of where the model I like, but I would also like to know whether the part two that you didn't quite get to would also be better for the Privacy Commission process and clearer for the process.
So what 2 under 107(1)A gets at is that it suggests that a tribunal exists. So it says that the organization has contravened this act, and 2, the tribunal has dismissed an appeal of the finding under subsection 103(1). So the gates for getting a private right of action are 1. The Privacy Commissioner has understood and made a violation, and that finding is not under appeal. So you're not still in the process. You're not taking a shortcut and trying to get around the issue that the Privacy Commissioner is still considering this. And then if a tribunal exists, or 2, that the tribunal hasn't already ruled on this and dismissed this, and then or B, that the tribunal has made a finding, so that the tribunal has actually come to a conclusion on this matter. So 2 and B, so A2 and B contemplate the existence of a tribunal and its role in the private right of action.
And that's what I don't want. So, I really appreciate the thoroughness of your response. And I would, at the appropriate time, Chair, seek consensus if perhaps the sub-amendment included A, if to finish the first part, and then A, and then part 1 of the bill. I think that that's what I would propose to find some consensus. Thank you, Mr. Chair.
Just Mr. Massé, I'm not sure that I follow. Are you moving to?
Yes,
I can't.
I'll move a motion, but I didn't want to cut off any speakers as I'm not in the room, and I didn't want to inadvertently cut off any speakers if anybody else wanted to do. But if not, I would be prepared to move an amendment to the amendment to the conservative amendment that includes.
Mr. Massé, I'll just to be procedurally a little more elegant. I think I'd rather deal with this sub amendment, and maybe you can move afterwards. Just one sec.
Yeah, thanks.
That's what I had in thought, Mr. That's what I had in mind, Mr. Massey. So we'll deal with the sub amendment of Mr. Perkins first, and then you'll be able to move your sub amendment in due course. But but if you want some time just to explain it so that members know what's coming, sure. I can defer the floor to you.
Sure, I'll be real quick. I just want to make sure I was doing this right, because I would have to reinstall once we pass Mr. Perkins' sub-amendment. I would have to then reinstall sections A and 1. And what the consequences I'm seeking is that the tribunal would be the first course of action, and that would precede any court cases. So we would have the Privacy Commission, not the tribunal, sorry, the Privacy Commissioner would be the first stop in decision-making process, and then from there, the court system would be engaged if someone sought that. I think that would be a better process than having the two-track process that's been identified. Thank you.
Okay, thank you, Mr. Massé. So just that was just as a point of information for members to know what might be coming. But in the meantime, Mr. Massé, if you want to move this sub-amendment once we're done dealing with the one currently before the committee, please prepare it in writing so that it can be distributed to members. Et sur ma liste, j'ai Monsieur Garon.
Mr. Garon, thank you very much, Chair. If I understand what you've saying, if a person decides to, for example, in Quebec, if someone was a victim of violation of the law and decided to go to the civil court for damages and reputation, then that person, if the commissioner has not done its inquiry and there would be available, then the court would be available for them to go to the courts. So because basically, with regard to for just for information purposes. I don't want to offend Mr. Turnbull, but the fact that if we allow the commissioner to deal with the case first, so undertakes an inquiry, makes a report and a recommendation, and then if subsequent to that a person wants to continue the case, they will be able to go to a civil court, the Quebec court, civil court. And so here we eliminate A, I, 2, and B. Then that means that a person could go to the courts without having any report from the commissioner, and then the person would have to pay the costs of the course, and that could be damaging to the individual. Yes, have you? Yes. So yes, that's good. Thank you very much. It's I'm very happy to be in agreement with you, but. And if we leave A and I, what would prevent an individual from waiting for the report of the commissioner to then go to the tribunal of the commissioner afterwards? Because my point is that I have the impression that even with the proposal from Mr. Massé, we're taking an option away, because nothing can prevent someone from going to the commissioner or the court, and if a person is in a hurry, they can assume the cost. And so is it important for them to have the report from the commissioner first? If I've understood what you're saying, if we proceed, if we have one A and I and double I, that requires going to the commissioner first. But my question is, if we remove A and I and double I, what's what prevents them from waiting for a decision from the tribunal or from the commissioner without going and then going to the courts? No, even if we don't require, or the law doesn't require an individual to wait for a report from the commissioner before going to the court, that person could decide to go ahead and go to the court. But if you go to the civil court for a violation under this law, the law requires that the person must wait for the decision from the commissioner. The only route of action would be the commissioner. Mr. Gowell, I required a unanimous consent to continue because there is now a vote in the House. Does the committee wish to continue with your question? I see no objection. Thank you. 10-2? 10-2? So around 10-2.
Yeah. Yeah. Okay. Thank you, Monsieur Gao.
Mr. Gao. My question is, what you said, that taking away A and I, that would increase costs for a person that would have to go to a civil court if they chose to go to a civil court in Quebec, for example. But even if we remove A and AI, the commissioner will make a report. The question is, what use will be made of the commissioner's report by the civil court or even at the federal level even? If we remove A and I, and if my rights have been violated and I decide that I want to go to the Quebec court, do I still have the option to wait till the commissioner has done their inquiry? Is this an option before going to the court? Yes, there's the option that the person may wait for the report from the commissioner, and there's no requirement to go to the court afterwards either. So that means that in the worst case, an individual, even if we take away AI, the person could be required to wait and then go to the court and use the information from the commissioner's inquiry in the court. And if a person wishes, for their own reasons, to pay for the costs of a court case before waiting for the report from the commission, they could do that as well. So the costs are not necessarily that high for a person, and it's not doesn't cost any more to delay either. There is one option. As you said, there's one option for an individual who wants to wait and wants to take advantage of the inquiry by the commissioner in a subsequent court case. But there is also for the person to not wait and to assume the costs. And for a person who decides not to wait for the commissioner, there's also the problem of a conflict in interpretation of the law, because then the court would be responsible for deciding if there's a violation, without the decision from the commissioner. But in any case, if the individual is unhappy with the commissioner's report, especially with regard to any penalties, then there is the possibility to go to the court, provincial court, to seek penalties. So even if we leave A and I, there could be both possibilities are available for penalties. With regard to penalties, yes. That's an important issue because it's an issue of penalties, and this is the open question, and this is a way of separating the concept of a violation and then penalties. But there are two options for the decision with regard to penalties. So you could say, well, here there's a violation based on the work of the commissioner. I want penalties, and I'm not happy with the penalties proposed by the commissioner. And the same, the tribunal can deal with the issue of penalties and not the issue of a violation, which is the commissioner's role. But I was asking the question because when Mr. Turnbull was asking you, it wasn't really clear that if we remove A and I, the only possible result is to increase costs for an individual who wants to get justice. Yes. There are cases where there could be costs, but they could be higher or lower. Thank you.
Merci beaucoup.
Thank you very much. Mr. Williams.
Thank you, through Mr. Chair. And I appreciate the discussion today. I think it is good discussion, but essentially bringing discussion back to the reason for these amendments is we are again looking at whether we in fact need a tribunal or we look at some other routes. And I think as has been indicated, there are other options besides the tribunal, whether that's the initial complaint requirement. One we haven't talked about is an escalation to the courts requirement. These are all going to come into the same section when we get to it. But coming back to the changes that we're trying to make in the initial amendment that we're dealing with is whether the tribunal was needed at all. And I think we've heard arguments on both sides that, certainly we can look at the option of a tribunal and we've gone through what happens with the courts and how we go through that process. Or we give more power to the OPC as they've asked for, and then we look on this section and others to see what other amendments we can make to ensure that the public have options. And I think I've heard from you, Mr. Chan, arguments almost on both sides when you're arguing this, because last time we were here, you were talking about how the problem with and why we needed the tribunal was that the OPC was going to be overtaxed, overburdened, and the tribunal was a way to alleviate that. I think private right to action actually also alleviates that in some ways, because there's going to be other ways that the public can go and find a dispute mechanism without having to go through the tribunal. And I think the tribunal, the way that it's been brought in it was an idea. I think, again, we would be one of the first, the only G7 nation to bring a tribunal in. The rest of the nations are working just with more power to the privacy commissioner. And it seems that that's still the argument we're at, whereas Mr. Turnbull brought up a lot of arguments to say, well, that this is going to clog up the system, or we're going to have different decisions made by different courts. But if we had an escalation to the court's requirement, or again, we looked at A and 1 of this section, certainly that would in some ways alleviate those concerns and make it a little more simpler. It still, to me, does not make sense why we couldn't make those changes as been asked for from the privacy commissioner without creating this tribunal, which is just another bureaucratic layer. Have we looked, I guess the question is, we haven't talked about it now, but could escalation to the courts or something that would be written that stated if the tribunal had taken too long with a certain decision, that it automatically would go to the courts? Is that another remedy that would allow us to look at more power to the privacy commissioner without having a tribunal?
So thank you, Mr. Chair, for the question. I think it's important to make sure that we're segregating the arguments in their kind of purest form, to make sure that we're understanding where the considerations or the concerns that are being raised are. There is a rationale about courts versus tribunal in terms of resources and capacity, because in the instance of the creation of the tribunal, you are essentially creating a purpose-built body for the purposes of administrative monetary penalties for privacy violations. That's not about the OPC's resourcing, because actually it's about the tribunal as a standalone body able to understand and issue amps as opposed to the courts. That's one argument that is. And just to, in the alternative to that would be the OPC could administer those, correct? So there is a consideration around whether the OPC issues those amps. That introduces a different set of considerations. One is you're converting an ombuds that was created as an agent of parliament. So an ombuds that has a very particular function. So an ombuds is not a determinant body. It's an advice-giving body. It's why it was created as an ombuds, because of the nature of an agent of parliament. You are entrusting an agent of parliament and moving them from an ombuds function to an enforcement function. And you are, insofar doing, grouping an investigatory function, a findings function, and a penalties function, which, by all considerations of natural justice and administrative law, there should be appropriate mechanisms in place to segregate those functions. We do that in a number of particular types of instances and ways in which we can contemplate how to separate those functions. But essentially, you've got two considerations there. One is you've grouped them all, which we have concerns with, because that's not, to our mind, a consideration of how you actually achieve natural justice, nor administrative and due process. The second is you've given it to an agent of parliament, which is presiding over private sector actors, whereas most agents of parliament preside over government functions.
Just to interrupt you there, I mean, the alternative is the tribunal, which would then in some ways still be an agent of parliament, because some of those positions as listed would be appointed by either the minister or by parliament.
Except that in our West, without kind of nerding out and getting too down the weeds, there is a distinction to be made from agents of parliament and GIC appointees. GIC appointees act under the minister under their authority set out by statute, which means that there's a line of accountability from the Westminster system, from the duly elected government downwards to the appointee, as opposed to agents of parliament who are appointed by some summary of parliament but are not actually accountable under the statutory obligations set out in a particular piece of law. There is a material difference between those two things in terms of how one understands natural justice to have occurred.
And just so looking, and we've had these discussions before, but looking at other G7 nations or other jurisdictions, are they not putting the AMPs into the privacy commissioner function? Are they not doing what you're saying is not?
So there are a number of models out there. The particularities of our situation, in which you're converting an ombuds function into an enforcement function, and then putting them with the AMPs, is actually quite distinct. And so I'll let Mr. Chaba weigh in.
Thanks very much. I think as we discussed last week at this committee, it's important to recognize that when we do analysis on these kinds of issues, we do it in full view of the totality of the systems in which we're looking at. It's not just about picking out any one specific element and saying, well, that's the same over there, why can't we do it the same way? As Mr. Sean just mentioned, we're talking about a particular constitutional construction here in Canada where we've got an officer of parliament in the first instance. Nowhere else do we find it structured that way. So right away, we've got a distinction that needs to be made about, well, what could fit well within that construct? Second, as we discussed last week, there are a number of jurisdictions internationally that separate the function of the investigation work, the adjudication work, and then the decision-making around penalties. I mentioned, I think, last week that Australia separates it. The commissioner in Australia may seek civil penalties from a court body. Ireland also separates that function. In New Zealand, the privacy regulator cannot issue administrative monetary penalties, but costs and damages may be awarded by a human rights review tribunal. In Quebec, for example, the CIE is essentially a tribunal function built into the privacy regulator. There are many, many, many instances. In fact, as we discussed last week, it's generally understood that in order for folks to be able to have a fair and impartial hearing and to have the process stand up under scrutiny and not be subject to a very significant risk of challenge on the basis of a reasonable apprehension of bias, that you would need to separate those functions, that vesting a single individual or a single individual's office with the responsibilities to be both the ombuds, the investigatory function, and then the adjudicative function would significantly open up to challenge.
Mr. Williams, apologies, we'll have to leave it at that in order for members to head back to the House for the votes. But I want to thank our witnesses. Merci, Monsieur Chan, Monsieur Chabra, Madame Eng.
Thank you, Mr. Sean, Ms. Angus, and Mr. Sean. Thank you, and we will see you again on Wednesday. Thank you very much.